Welcome to my pod, Family Law Uncensored. I'm your host and family law and family formation law practitioner. Today I will be talking to you about adoptions, and because there's so many, we will start with a step parent adoption. Step parent adoption should be the least controversial adoption process at all because in a step parent adoption, you have a birth parent who has a partner, and that partner wants to adopt a child who comes from a birth parent. So, couple of things. In every adoption, including a step parent adoption, there are a couple of requirements that have to occur before adoption proceeds to the next step. Number one, there has to be a home study. That is done by a personnel of the Children's Court, which is located in downtown Los Angeles and Monterey Park, I should say. And fittingly, the name of the court is the Children's Court. The staff of Children's Court, and specifically the Adoption Court, is the friendliest staff on the planet. They want to make sure the family gets formed. They want to make sure everybody is moving forward. And they want to make sure that adoptions proceed without many hiccups. The clerks are the friendliest, the judges are the friendliest. That's not to say that they're not going to observe the due process, but they will be happy to help you along the way. I call that court the happiest place on earth, not the Disneyland. You still have to do the work, and that work requires you to participate in the home study, provide all of your certified documents to the court so the court can make sure that everybody is up and up, to make sure that the adoption is finalized in a quicker fashion and the new family is moving forward with their lives. The next step is going to be you have to, if the child is above 12 years old, the best part and the funniest part and the most interesting part for the child is he or she gets to sign a form saying he or she consents to the adoption. I cannot tell you the number of smiles I have witnessed at the courthouse when that child presents a form to the judge and says, "Yes, Your Honor, I want to be adopted. Yes, Your Honor, that is my stepdad. He raised me. I want to be adopted by him. I want to carry his name. I love him too. I want to be a part of that family. Thank you, Your Honor. Here's my signature." The best time, the best place, and the best family, and the biggest smile you'll ever see at that courthouse is when the child signs that form and tells the judge, "I want this." For the step parent adoption, the biological parent's consent has to be obtained. If it's not obtained, unfortunately, it's going to make the case go longer and it's going to make it more expensive. If a biological parent does not consent to the adoption and does not provide consent voluntarily, then his or her parental rights will have to be terminated. And that is done at trial, and that is when an adoption case, which otherwise really should not be a trial case, becomes a contested issue. And we have to have a hearing. It's called a TPR hearing, a termination of parental rights hearing, which again will have to be done in court in the adoption court department in Monterey Park. And unfortunately, it's not on seldom when it happens. It shouldn't, but it does. I've done those hearings many times. It makes the case more expensive. It makes the case a little more nerve-wracking for the biological parent who is on the other side of the case. But if it has to be done, I'm going to be there to do it because the goal is for the new family to be formed and for the child to have a new family going forward. There are a few instances when a biological parent's consent is not required. There are a few of those, but they do exist. A biological parent's consent is not required when the biological parent who has the custody of the child does not know where the other parent is. It does happen, not frequently, but it does occur. The other instances where the biological parent who otherwise should be providing consent is not in this country and cannot be found, even though we think we know where he or she is located, but that is also a possibility. And the last thing when the biological parent should not provide consent is frankly when the biological parent is deceased It's a smaller issue, less controversial, but I have to tell you about this because that's on the books. When the adoption is being finalized, a judge will inquire from the prospective adoptive parent, and that is the parent who wants to adopt the child, whether that prospective adopting parent understands that he or she will have new rights and responsibilities with respect to the child he or she is about to adopt. When that occurs, the admonitions are if they know that this child will then become their child as if that child was born to them. Whether this prospective adoptive parent understands that the child they're about to adopt will be able to inherit from this adoptive parent. That they should know that this child who they are about to adopt will be entitled to be protected by this prospective adoptive parent, to be provided food, shelter, and all the necessities of life. In other words, any prospective adoptive parent, whether it's a he or she, need to understand when they adopt a child, that child becomes their child, and they will have to care for it, for him, for her. They have to listen to him, to her. They need to make sure they provide educational opportunities for him or for her, and they need to make sure that the child enjoys the rights of being able to be raised in the adoptive parent's home. The court's role in approving a step-parent adoption is frankly huge. To simplify this, the court's role in any case and in the step-parent adoption is to make sure that the process is followed, to make sure that the adoption is finalized, to make sure that once the court signs the adoption order, there's no turning back, to make sure that when the court says you now have your new family, that family is ready and able to move forward as a family. The court's role in this is to make sure that the due process is followed, and the court's role is to, frankly, to make sure that new family understands that they are now a new family. And the funny part is, and the soul searching and soul fulfilling part is when the court gives a new family at the end of the finalization hearing a certificate of new family. And they used to also give out teddy bears when we did it in person, but that was before COVID. Seems like a different universe by now. But there's a good stuff that you need to look forward to, and we do. I look forward to finalization hearings. I cannot tell you how much I look forward to those hearings and how happy I am to see families when they're done and we know that they're now a new blended family. In a step-parent adoption case, like any other adoption case, the emotional challenges I face with families as their attorney are sometimes arise in the context of if a biological parent is not consenting to adoption, that presents a challenge. And for the family who wants to adopt a child, presents a huge emotional challenge because put yourself in the shoes of a prospective adoptive parent. I'm here, I'm ready to accept this child as my own. And there comes somebody who had not been in this child's life, let's say, for the last 5 years. And that somebody, just because he or she is a birth parent, will not allow us to be a family at this point. That is a huge challenge. That is an obstacle. That is an emotional obstacle. That is going to be a financial obstacle. That is going to be also a time obstacle because that is now going to take more time out of our lives before we can actually become a finalized family with a finished adoption case. To prepare families for the adoption process, I have to tell you two things. Number one, when we are taught how to become a lawyer, or better yet, when we are taught how to become a better lawyer, we are taught not to personalize cases. Just like doctors are told not to personalize their patients' cases with them, we are told we should not bring our work home with us. However, it doesn't always work. It does work infrequently. I have not learned completely how to do this, and so I bring those cases home with me. But I will tell you that to tell my clients how to deal better with emotional roller coaster of the adoption cases is not always easy, because all I can tell them is that as a lawyer, I make suggestions. I give advice that is based on legal expertise and legal facts. I can't tell them that they should separate their emotions from the legalities of their adoption case, because that's not humanly possible. Everybody is a human, and we act as a human being, and we react as a human being. And as a human being, we can't separate our emotions. It's the goal, but it's very difficult to accomplish. Judges are humans, or we think they should be humans. We expect that they should be impartial. Most are, sometimes they're not, because they also can't always separate their emotions. And then that's when we deal with the fallout of the case. However, and I have said it in other cases, and I have said it in the context of a family law case, not just a step-parent adoption case. The goal is the better separation of your emotions from the facts of your case that you can accomplish, the better off your case is going to be. And that is difficult to achieve, but I'm going to be there with you. I'm going to help you to go down that path. I'm going to help you to try to separate the inseparable, but that's the goal. To qualify for step-parent adoption, as the name itself suggests, a step-parent assumes that the step-parent is married or is in the relationship with the biological parent. So California is probably one of the more liberal states for adoption cases. Pretty much any status will satisfy. You don't have to be of a certain age, although the court will want to make sure that you're of able body to provide for your new child. The court will want to make sure that you are sufficiently financially stable to go through the adoption process. In California, in step-parent adoption cases, as the name would suggest, step-parent adoption presumes that a parent who wants to adopt a child is either married or is in a relationship with the biological parent. My topics in the podcast are limited to California cases. Because I'm licensed in California, I'm also licensed in Massachusetts. If you live in a different state, it's important to get advice from an attorney from the state where you reside, because, as I have stated before, over and over again, cases are state specific. Law is state specific. This is not one size fits all. You have to know your size, you have to know your state, and you have to consult with your state attorney who specializes in family formation and adoption cases to get adoption specific advice. The best advice and best tips I have for families who go through adoption process to ensure that the process goes smoothly and fairly quickly and fairly inexpensive is to make sure you provide to your attorney all the information the attorney is asking for, or even information the attorney may not be asking for, because you know your case, you know your family better than any attorney ever will before the attorney embarks on the way to file your adoption case in California and any other case you may live in. So in the adoption case in California, it's important to allow your attorney to collect information voluntarily from you without having to, pull teeth. We need information about your marital status. We need information about your finances. We need information about your household. We need information about your prior relationships, whether they were finished and finalized voluntarily with the judgment of prior dissolutions. We need all of that. I also need to know if you have skeletons in your closet. I need to know that, because if the home study comes about and the social worker finds that out before you tell me, I will not be happy. I will assume that you have things to hide, and I will assume that you will not cooperate with me and the court, and I will assume that you really should not be my client. But if you want your step-parent adoption or any other adoption case to proceed smoothly, your voluntary disclosure of information to me or any other attorney you may want to work with, but myself primarily, should be provided voluntarily and quickly. If you have any questions about step-parent adoption or any other adoption, on surrogacy or fertility cases or family law issues, please feel free to reach out to me. Facebook, Instagram, Messenger, email, Twitter, Viber. What else is there? Whatever social media you can think of, I'm out there in the universe, easily foundable, easily reachable. Oh, I forgot email, the oldest way to find me, or text message. Please reach out, click, like, subscribe, or send me your questions. Happy to answer them. All the contact information about my office, about myself, is available in the podcast. You can easily reach out to me in any way you want. Social media, email, click, post, whatever you like. Call me with questions. I like questions. I think I'm pretty good answering questions. The more questions, the better. Talk to me, I'll talk to you.